I'm Mike Larsen. I am the president of the BC Freedom of Information and Privacy Association. Today I'm introducing a short video based on an event that we held called Environmental FOI 101. This was an introduction to freedom of information process and a discussion of some of the challenges associated with FOI, geared specifically towards individuals and groups who were involved in work around environmental issues. And I was joined for this event by Professor Sean Holman, who's the Associate Professor and Wayne Cook's Professor of Environmental and Climate Journalism at the University of Victoria, one of the most experienced investigative journalists and researchers doing work on environmental issues using FOI, and really delighted to have his expertise with me on this video. We talk a bit about some general tips on filing FOIs and some challenges associated with that. We talk about some of the common issues that arise around the phrasing of requests and around requests in process, some of the types of records that are more difficult to get and why under FOI regimes right now. And we had a good discussion running throughout this video about the historical connections and contemporary connections between the transparency movement and the environmental movement, and how it's incredibly important for environmental activists to be actively involved in work on transparency reform, which is certainly an important issue for us here at FIPA. So I hope you enjoyed the video, and I hope you are interested in future offerings from FIPA around issues of information and privacy. Thanks very much.
FIPA acknowledges with respect the Indigenous peoples on whose traditional territory we conduct activities. While striving to increase privacy protection and access to information for everyone, we recognize that colonization and associated attitudes, policies, and institutions have significantly changed Indigenous peoples' relationship with this land. For many years, those same things served to exclude Indigenous peoples from the privacy protection and access to information afforded to others. FIPA is committed to redressing these historic and continued barriers. And we acknowledge the insight and knowledge of elders past, present, and emergent, and the relationship to this land and these issues.
So, here we are, Environmental FOI 101. We are starting with a couple of assumptions, and one is that people are generally familiar with the idea of FOI, so we're not going to spend too much time on the basics. We want to get into some of the stuff that's really geared towards environmental requesters and requests, and some of the issues and challenges that we face here. So I'll get rid of the preliminaries pretty quickly by talking a bit about the basics of the FOI process and then passing it over to Sean to give us a bit more of a historical dive into things. In Canada, we have multiple different freedom of information or access to information systems, which we could call FOI or access regimes. And generally, these are based on the legislation that applies. So, for example, we have federally the Access to Information Act, which pertains to all federal public bodies. And then provincially and territorially, we have provincial FOI legislation that pertains to the public sector aspects of those provinces. In British Columbia, for example, it's the Freedom of Information and Protection of Privacy Act that covers everything from the, Premier's office and other government ministries, all the way down to municipalities, right? So long as it is a public body in British Columbia, it's accessible, with some exceptions under the provincial FOI legislation. And that's very important at the outset, because one of the first things to know when we're starting to work on FOI requests is the matter of jurisdiction, right? Who has control of the records that we're looking for in terms of level of government, but also in terms of particular agencies. We also have, we should note, in Canada, we have legislation that applies to some municipalities as well. So, for example, in some jurisdictions like Ontario, there's separate FOI laws that pertain to municipal FOI requests. And in British Columbia, we have separate FOI laws that pertain to certain First Nations. So, for example, Tsawwassen First Nation has its own FIPA. So, first thing we need to know is, which level are we dealing with? Next thing I'll say, just in terms of preliminaries, very important to note that all of our access laws, federally, provincially, they're really dual purpose laws. So on the one hand, they're going to recognize a right of access to records that are held by public bodies that we can use to access information, but the same laws actually spend arguably even more time and space covering the provisions for government secrecy. So every access law is simultaneously a transparency, but also an opacity law. And you can see these things really coming into conflict. And we'll talk today about how to navigate some of those challenges there. My final point that I want to make in terms of preliminaries here is that with all of these systems we have in Canada, provincially and federally, there's a standard process, which is that the requester is going to prepare and file an FOI request, and that's going to be received by an access to information or FOI analyst, whoever it is who's responsible within that public body for receiving and processing those requests. And they, in turn, are going to be looking for the information that we're asking for from what's called the Office of Primary Interest, or whichever public office within that body actually holds the records in question. And it's always a good thing to remember at the outset, because sometimes we get into the situation where we think, well, we're filing an FOI request with whoever actually has the records, right? Whoever is a knowledgeable specialist in the area. And there is that intermediary, right? There is that middle person there, the analyst, who has to interpret what we're looking for, task that to the Office of Primary Interest, and kind of act as the middle person in the correspondence back and forth between. For that reason, it's always important to be as clear as possible when we're dealing with FOI requests and provide as much information to make sure that gets tasked effectively. And Sean, I'll turn it to you to add on to that.
Yeah, so this is a sort of really interesting regime, and this is a regime that has existed for a very long time in Canada. This was born sort of in the 60s and 70s. Folks were advocating for that system back then, and it really sort of started to come on stream in the late 70s and early 80s. But what's really important to also recognize as part of this conversation is some of the historic origins of freedom of information, because they are bound up in the environmental movement really tightly. So coming out of the Second World War and following the detonation of the atomic bombs over Hiroshima and Nagasaki, there was a real desire to really figure out, okay, what had caused the world to go to war twice in the span of just a couple decades. And one of the big answers that sort of was sort of advocated for to that question was it must be the fact that if only Germans, right, if only German people had known what was really going on in Germany, if they had only known the truth of the Nazis and what they were up to, that they would have never gone to war in the first place. That if the Nazis hadn't distorted the facts in their own propaganda mill, this all would have never happened. And this idea was really advocated by Franklin Delano Roosevelt. He was a big believer in freedom of information and the idea that information would lead to peace, and the idea that information would give people more control and certainty over the world. That with information, people would make better decisions about the world around them, and therefore they would also feel more certain about what was happening in the past, what was happening in the present, and what was happening in the future. And this idea, right, of the power of information, that evidence equals action, was really carried forward by three movements during the 70s. First was the consumer protection movement, Ralph Nader. The second was the investigative journalism movement, so Bob Woodward, Carl Bernstein, and all the muckrakers from that period. And then the third was the environmental movement. Rachel Carson, the author of Silent Spring, her favorite quote was from the French philosopher Jean Rostand, who wrote that the obligation to endure gives us the right to know. And this idea, right, that information, that evidence would equal action, really parades throughout the politics of the post-war period. And right up until the present day, we are all informed. The work that we are doing, whether or not journalists, whether or not we're academics, whether or not we're environmentalists, the work we're doing is all informed by this particular formula, by this particular idea, which is really something important that we need to keep in mind as we sort of talk about freedom of information today.
Fantastic. And of course, the laws are consistently evolving. One of the themes that might be of interest to everybody here is that we're currently in a process in British Columbia, and indeed federally as well, at looking at our laws and seeing about opportunities for reform. There's a special legislative committee in BC that's looking at the FIPA and receiving submissions right now from anyone who's interested in talking about transparency issues and the need for a better law. And certainly that's something that FIPA is really actively involved in, trying to carry through some of those, I think, really simple principles, right? The general right to know, and actually translate those into efficacious policy. I'll move on here and talk a little bit about us getting started with filing requests and starting to prepare. And this is something that Sean and I want to spend some time on, is kind of getting into some of the nitty-gritty stuff. I have found in my personal experience that one of the most useful resources for people who are just getting into FOI is previous requests, is being able to look at the work that's been done by others who've come before us and to be able to build on that. And we are in some ways fortunate to be doing this work in this time period, because increasingly you're seeing different governments across Canada starting to host their FOI materials online that have been previously processed. BC's actually pretty good at this, comparatively speaking. So I've got those resources here. You can see on the screen that through the BC Open Government portal, everyone can go and you can take a look by ministry. You can take a look by keyword, although that's a little bit tricky because the keywords only capture the content of the request, not the release packages. But you can take a look by date. You can browse, and there's no cost associated with this. So you can go and see what's come before and start building on that material. There's two reasons I find this to be particularly important. And a lot of people who are involved in FOI work on environmental issues are also looking at, by definition, issues that are politically contentious, that have been subject to some contestations around transparency and the right to know and secrecy. And so when people have met with success, when they have sought to obtain records that pertain to issues around climate and environment, and that's published online, you can use those as examples of record types that might be useful to file for, right? Some of the really nitty-gritties, like particular types of reports or particular kinds of briefing notes, they're good examples of what's out there. Many government bodies don't actually publish good lists of the types of records that they actually have in their holdings. So this is a good way to get that foundational work done. And the other reason for this is that through, for example, the BC Open Government portal, you get a chance to see not only the release packages, which you can download as PDFs, but also the request phrasing. And both Sean and I are educators, and so usually have admonitions about plagiarism and copying as part of our material. But to be honest, when it comes to FOI, if somebody has filed one successfully and used wording that seems to have worked, borrow it, steal it, use it, repurpose it. So that's two reasons why this is quite useful as a starting point. So this is the provincial, and you can see also federally. Federally, it's a little bit clunkier. On the one hand, you have a one-stop shop where you can go, and every single federal ATI request that is published through this one portal. However, for the vast majority of government bodies, they're not actually publishing full text of the request. What they're publishing is the summary of the request, the number of pages as well, and then you can actually make an informal request to receive a copy of those records. Now, there's no limit on how many times you can do that. So I always say when people are starting a new process of research or getting into a new project, the first thing to do is to spend some time with these resources and really, gather as much as possible. It's already out there, and then you can build on that as you go.
Yeah, and what's really also important as you sort of work your way through this process is to sort of think about government as an iceberg. This is the metaphor that I often like to use. We see only a very, very small portion of the stuff government does in public. But behind every single thing that the government does in public, behind every single thing that we know about, there is an absolute and complete mountain of paper that exists justifying those decisions, that relates to the making of those decisions, that relates to how exactly those decisions are made and what considerations were at play at that particular time. For a long time, I would actually use in my own classroom work the example of one of then Premier Christy Clark's trade missions to Asia. And that trade mission to Asia, you saw the news release come out, you saw various different social media postings related to it, and you could probably fit all that public stuff, within sort of this amount of thickness of paper. But I actually filed a Freedom of Information request for everything behind that particular trade mission, and it was about this much paper. So it's really important to sort of use those things that you're seeing publicly on the surface as the hook for filing Freedom of Information requests for information that's floating below the surface. And that's really one of the most sort of effective ways to sort of think about the system and think about your sort of own process as you start filing these Freedom of Information requests.
Absolutely, and you'll see that we're full on with metaphors today. So I like to refer to
Yes.
kind of like the information onion of government, and we have the iceberg. But I think our next one, which you can see here on the screen, is a really useful way for thinking about what is available under FOI, and then also what is more challenging to get under FOI. And this goes back to what we talked about at the outset, which is that all of our transparency laws are also laws that deal with clauses that can allow for governments to withhold information, or indeed categories of information that are exempt from access, or particular bodies that are exempt from access. So there are some, actual public bodies that just are not scoped into our access laws. Offices of the legislature in British Columbia, for example, having gone through recently a very scandalous experience with some misappropriation of funds and whatnot in the legislature. Well, those bodies just simply aren't coverable by our FOI. But there are also types of records that fairly commonly across Canadian jurisdictions are difficult to access. So I think Sean has this really useful metaphor of buckets that we can talk about in terms of what you can get at.
Yeah, absolutely. So you really want to think about the records that you get from government into three buckets. Okay, so the first is what government knows. What government knows about the world. Now, you can get pretty good access to this particular information within the constraints of personal privacy, and this next one is important, third-party business interests. So as an example, it would be great to be able to get information about mine inspection reports, but sometimes, again, what government knows about the world, or what government knows about what mines are doing, various different violations of regulation. But sometimes that's compromised by third-party business interests. So again, we have okay access to what government knows about the world within those kind of two broad constraints. The second one is what government is doing. So what government is doing about all these things that it knows about. And again, our access is okay. It's a little bit more constrained, though, because government doesn't allow you to know about specific kinds of activities or know a lot about specific kinds of activities. So law enforcement activities, for example, there's a big hurdle to sort of get some of the information around that. National security issues, again, another sort of big hurdle as well. So you really want to keep that in mind when you're sort of filing for information about what government is doing. There's a third category of information, though, that is really important to keep in mind, and that's why government is doing all these things. And we have almost no access to that, which is frustrating. And the reason why we have no access to that is because our system of government makes an assumption that decision-making must happen in private. So that's the assumption that underpins cabinet confidentiality. And then that's the assumption that sort of flows throughout government, which is why you see things like exemptions for cabinet records, but also exemptions for policy advice, because there is this bias in the Canadian system against the idea that decision-making can actually happen in the open. So as long as you sort of keep these three buckets in mind, you will be less frustrated with the system because you'll know what you can get, you'll know what can be valuable out of it, but then you'll also have a better understanding of what is sometimes really difficult to access.
Just to add on to that, this is also really helpful when it comes to phrasing requests and actually composing requests, which we're going to get into in a few minutes here. But sometimes we find that if you are asking for a lot of information about, say, let's say what government knows, some reports and assessments that have been received, internal statistics about things, some trend information, that's often accessible information. But if your request also includes, let's say, briefing notes to the minister and advice on courses of action, you've got that in the same request, so two different buckets. It's legally a viable request. You may encounter some exemptions, but the complexity of getting at that why government asks or acts bucket may actually delay the request and make it harder for you to get access to that what government knows material. So thinking about this at the outset, thinking about, well, what is the most uncomplicated way I can file this to get this information, and then perhaps filing a separate request for this one that you anticipate being potentially more contentious. And it's a good tip is that if you take a look at previously released requests that have been successful, you'll find that a lot of them are fairly focused in scope. You can ask for that kind of, I call them the kitchen sink request, right? Give me everything about this and everything adjacent to it. Those can work sometimes, but they are often going to encounter the delays that are built into the system. In our different FOI regimes in Canada, you have a statutory turnaround period on when government has to respond to your request. And depending on the regime, it's usually 30 business days or 30 calendar days. Now, that response can be, here are the records, or that response can be, we've received your request and we're taking an extension due to the complexity of locating the records of interest, due to the amount of requests we already have in play. There's a lot of politics that go on with this as well. But trying to figure out how you can make these things focused, I think, is helpful at the outset. Now, for environmental researchers or for people who are interested in issues around environmental justice and climate, it's useful to think about some of the types of records that might be really good targets in these different kinds of buckets, acknowledging some of them might be challenging. So, for example, why government acts. It is possible to get briefing notes for senior officials there. And I find even though a lot of the stuff that's really interesting is going to be redacted, as Section 13 in BC, which is about policy advice that Sean mentioned, a briefing note's actually a really useful thing to have for everyone who's filing for or doing work on any of these issues, because it shows you how a government is distilling the essential information about an issue into a package that's actually accessed by senior officials. And sometimes that in and of itself can be revealing what's included, but also what's excluded. In terms of what government is doing, one of the common targets for requests would be correspondence. Who's involved, getting at email chains. And that I think is really useful as well, because you can see how these multi-jurisdictional projects unfold via communications. Who's briefed, who's looped in, who's at the meeting, who's receiving the agenda, those kinds of documents being quite useful as well.
Yeah.
Any other documents?
Yeah, and just sort of add to that, one of the things that you really, and just to sort of reinforce the point that Mike just made, one of the really important documents to get is those stakeholder communications, because what we know is a lot of the action in terms of what government does actually happens outside of government as a result of lobbying, as a result of various different positions that various different parties outside government have taken. And you can actually get access to sort of anything that's actually coming into government within reason. And this is also particularly important because government doesn't have a lot of resources. So it often relies on industry groups, as an example, for the research used to sort of justify the projects that they're going to be undertaking. One of the Freedom of Information requests that I remember filing many years back was for information related to the Northwest Transmission Line, which was going to power a whole bunch of various different mining projects and fracking projects in northern BC. And what was really interesting about that was the entire justification for that came from industry. There wasn't any independent research done by government whatsoever. And again, that sort of goes to what Mike's talking about, which is those stakeholder communications, right? The information that's sort of coming into government is sometimes just as vital as the information that government in and of itself is actually creating.
Absolutely. And that notion of there being different stakeholders goes to, there's so many different record types we could talk about. We have limited time, but I think if I had to give advice on a type of record that would be really useful to look at that many people don't file for, it's memorandums or letters of understanding. Because many of the issues we're dealing with around anyone who's interested in issues around environmental justice, climate change, these often involve large projects, collaborations. And these are situations where you have different public bodies with different mandates, different resources, who are trying to figure out how they're going to coordinate and collaborate. And typically, that's going to be worked out via some kind of an instrument, an MOU or an LOU. That's ultimately kind of the follow the money document for a lot of these things, right? Who has decision-making power? Who has authority over things? Who gets to decide when and where things happen? That starts you off on the path of really being able to say, well, this is the major instrument, and how is it connected to questions around resourcing and budgeting, and how is it connected to briefings and consultations? And so whenever you can, trying to file for those, I think is very helpful there. And that would kind of fall into that middle bucket area.
Yeah, and really pay attention to like project charters as well internally in government. When government is doing something, sometimes they have a document which is called a project charter, sometimes it's called something else, but it generally sort of sketches out what exactly they're going to be doing on any given particular issue. But remember, again, to sort of keep in mind that idea of the iceberg, right? Oftentimes, government is doing things behind the scenes. So we need to come up with really creative ways, sometimes of looking for what's sort of in the public domain to get at what's in what isn't in the public domain. So as an example of that, there is a website that government has called BC Bid, which is full of all the various different contracts the government is actually letting, the government is interested in people participating and applying for. It's really good to check that on a regular basis, because generally speaking, if government is looking to contract someone to do something, that means it's capacity that they don't have in government. So it's generally speaking something new, potentially. So a really good example of that was I actually found out very early on about the struggle that the government was having with remediation of old gas wells. That there was some challenges around cleaning up those wells and some challenges around sealing them, simply because government had let a contract, had put out a contract for someone to actually do that work, to understand the extent of the work, and it included all this information about the extent of the problem that government hadn't released publicly, but they needed to release the contractors because they needed the contractors to understand the scope of the work. So then I filed a Freedom of Information request for everything behind that, and that led to a whole bunch of other interesting stories. So again, that thinking about government as an iceberg, thinking about what's out there publicly, and using that to better understand what you can ask for that's behind the scenes, really important concept.
Mm-hmm. Absolutely. And it goes again to the value of being able to access previously released requests, because hypothetically, had Sean filed that, just a couple of months ago, well, you would right now be able to go onto the Open Government website, take a look at the wording of the request, but also the release package in its entirety, and take note of the types of requests that would be useful for filing follow-ups.
Mm-hmm.
Just moving forward here, if we're getting into the idea of actually putting together an effective request, and this is sometimes a science, sometimes an art, I have a few tips here in terms of effective phrasing. And Sean and I have both filed too many FOI requests to count, probably. And these are some of the common ideas, I think, that bubble to the surface when we're talking about successful phrasing. So first off, obviously, selecting the correct target public body, really important. And that can be challenging. That's why getting those MOUs sometimes can be helpful, to know who is involved in a particular issue, who has ownership of the records. And sometimes there are multiple public bodies involved. So you may have to file the same request with 3 different public bodies to be able to really get a comprehensive picture of things. Sometimes at multiple jurisdictions if it's a federal provincial issue. You can use websites as a starting point for this. You can actually call FOI analysts too and just ask for some preliminary advice on phrasing a request. Quite helpful there. Describing the record types of interest is another key issue. So what specific kinds of records? We sometimes get into situations where people ask for all information related to X, which would be great if we could get access to all the information related to X. But for a complex issue or major project, if you're looking at, let's say, a pipeline project, for example, that's a vast amount of information. It's going to be almost impossible for an organization to kind of comprehensively compile and then review. So specifying particular target types of records, using some of the stuff we've just been talking about. Avoiding vague phrasing, right? And again, that's the idea of all information about X. And trying to be specific where possible. Sometimes there's reasons to be a little bit open-ended, but quite often if you can be focused, that's advantageous. This doesn't also have to be worded as a well-composed sentence. I like to use bullet points. So I'm looking for the following records related to this issue, 1, 2, 3, 4. That's perfectly permissible when you're filing an FOI request. The date range is also really important, and one of the ways you can avoid encountering delays and extensions with requests can be having a focused date range, maybe even filing multiple requests over time, each for a different date range around the same issue. That's also a possibility. Trying to think about, well, when would records of this nature have been generated? When would they be in the archive, and then when can we access them? In terms of as needed, so those ones on the left there, those are things I would do with every request I file. In terms of as needed, providing contextualizing information. It's interesting. Sometimes it's actually helpful to give information before you ask for it. And it goes in part to the idea that the people who are processing requests may not be subject matter experts in the institution. They're FOI experts. You may, in fact, know more about the issue that you're filing on than the people who are receiving the request. So if you can include, for example, on a statement says, on this date, the minister gave a public press conference where they announced this project, or on this date, the minister said this in legislature, or in this previously released FOI package, here's the file name, this information was released, and then you ask, and I'm looking for this. It gives them a starting point. A, it says, yes, I know that this information exists, or it ought to, because someone's been talking about it already. And B, it helps them to task things a bit further. So not always important, but sometimes quite useful. Sean?
Yeah, and I would often think about this almost like magnetic poetry in terms of actually assembling the request. So you really want kind of three core parts of the request. The first is what information you know, what it is that you know about this particular issue, right? So just say, on, as Mike was saying, on this date, right, the minister said this, or the minister did that, right? Or government announced this, or there was this contract with BC Bid that said this, okay? Then the next line, right, afterwards, the second sentence, right, in our little magnetic poetry creation, right, is what you want from the government, okay? So this could be any and all records, that can be legitimate, or it can be, please provide any and all of this specific kind of record, right, related to this particular issue. And another really important way of narrowing it down isn't just in terms of what record you're looking for, but also who actually holds the record. That's something a lot of freedom of information requesters sort of forget about. So what you could actually say is any and all, records held by people of, executive director level or above, right, within this particular ministry. And that really allows you to sort of get in sort of that top line, that most important information, right, that's sort of filtering out to the executive, that's sort of filtering out, to ministers, right, about any particular issue that you're looking at. So you sort of have, again, sort of the first line is that what you know, right? The second line is either sort of what records you want, right? Or who actually holds those records, or a combination of the two. And then, as Mike was saying, that third part of it is that sort of date range, right? What date range do you want those records for? And if you kind of think about it within that kind of magnetic poetry sense, right? Those three key sentences, you've composed a pretty good freedom of information request.
Absolutely. There are a couple of additional things that might be useful when you're thinking about this, and you can plug those into those different components Sean's talking about. One of them deals with format. So for some requests, I mean, the traditional image of an FOI document is, the paper document with blacked out lines. The way government has processed those over the years has been as a image-based PDF document, right? Basically, it's a photocopy, which has always been challenging because you could get 300 pages of FOI records and they're not searchable. They're not text searchable because they're flattened image-based files, sometimes with pretty low res. I was always impressed with how government managed to have large file size, but also low resolution simultaneously in the same package. But maybe you're actually looking for something that is machine readable. In other words, you're looking for data that can be used. And if that's the case, if you're looking for, internal data about trends, something that's actually held in the database or an Excel sheet of some kind, specifying that in the request, right in the wording and saying, I would like this in a machine readable or an Excel format is very important, because the default is going to be to have something basically that's outputted to PDF and printed for you. In fact, federally, some public bodies are still in the habit of sending you your release files as scans on a CD-ROM in the mail. So kind of thinking about, well, what do I need in terms of format? The other thing is record types that are not of interest. And this is particularly important if you don't really know what the information terrain looks like and you have to ask for, give me all the records within this level of office about this. But you might say, excluding correspondence. right? And that just helps to narrow down the initial search. Now, don't do that unless you want to exclude that, but sometimes you're interested in the reports, you're interested in the assessments and the briefing notes, and you don't want the 500 emails that might deal with this issue, and it can help to speed things up.
Yeah, absolutely. And sometimes, you want to do some freedom of information requesting before you actually do freedom of information requesting. So as an example, let's say you wanted a whole entire big data set from government, but you weren't really sure if it was actually worth requesting that data set. So instead, you can first file a freedom of information request for the data dictionary for that data set. And that dictionary, right, is the thing that actually includes, well, what actual fields, right, what actual categories of information are actually in this data set. And then you can kind of get a good sort of sense about whether or not it's worth filing a freedom of information request for it or not.
There's much to be said about this, but I'm going to move on here and talk about some tips when requests are in flight and in process, and some thoughts on some strategies that have worked for us, and then we'll have a bit of time for some questions and discussion towards the end here. There is going to be. Oh, did I skip past? Sorry. There we go. After you file, yeah. So one major thing with this is to keep track of correspondence, and I suspect if you're here with us today, then you've got some experience doing research, and you know the importance of documenting your process there. But having your own internal, a spreadsheet or a database that says, okay, I filed for this with this organization on this date, they acknowledged it on this date, and I'm expecting it to be in by this deadline. So important to be able to have that, because sometimes you do actually have to chase down organizations that have just let it fall off the table and are in what's called deemed refusal when they haven't responded within the legal timeline, but they have actually not also taken an extension. So you can call them on that. So keeping track of that, and also keeping track of who you're speaking with. Sometimes you get into a position where you're doing FOIs with the same organization, you've got the same analysts who are working on the file. You can develop some rapport. You can actually have that conversation back and forth, particularly if there's requests for clarification coming in. Sometimes, though, a request can change hands 2 or 3 times, and so it's important to always keep track of, well, who has control of your request right now in case there are any issues that arise. In terms of correspondence and challenges, for anyone who's filed an FOI request, the most common type of correspondence I think you're going to get is a request for clarification. So, for example, if you've said all of the records dealing with this project that are held by the Ministry of the Environment, they may come back to you and say, well, which offices within the Ministry of Environment in particular are you interested in? Are you interested at this level, the minister's level, associate deputy minister, these kinds of things, or the entire office? So just those requests that help you to clarify scope. Sometimes requests for clarification can be about the interpretation of a request, right? When you said this, what specifically do you mean by this? And that goes again to the idea that the analyst who has an obligation to respond to your request may not have the same background or subject matter expertise, or you may be using language that we use colloquially, we use every day, whereas government's using a very kind of internal bureaucraties when speaking about an issue. So they're trying to figure out how to translate what you want into language that's being used. Not an environmental topic, but I think the a good example I often refer to when talking about this is when I was doing research on deportation flights, chartered deportation flights that were being used in Canada some years back. I was asking for records about deportation from Border Services Agency, and they came back with, well, we don't have these records. And it dawned on me after a while that they actually use the term removals instead of deportation, meaning the exact same thing. But anytime you can actually refer to, government's own internal interpretation of things in their own language can help, because oftentimes these requests are going to be processed by basically doing a search of files or search of emails, right? Like a keyword search. And so using that language is appropriate. You're also, of course, going to get extensions. So it will be a letter acknowledging a request. And sometimes, depending on how busy the organization is or the complexity of the request, or just as a matter of whim, you will get an extension. And depending on the jurisdiction in Canada, government bodies have a discretion basically to take a 30-day extension without really having to provide any kind of serious cause or justification for it. And that seems to be the norm in a lot of jurisdictions. Sometimes they'll ask, would you permit us to extend this, asking for permission. Other times they'll claim an extension. There's really 2 reasons for doing that. One is the volume of the requests and the material that would be going through would unduly interfere with the operations of the organization, which is a resourcing issue, right? And the other is consultation. which is where we have to consult with multiple other bodies who are kind of in ownership of these records to see if there's any reasons we should withhold anything, any considerations there. And for complex files, that can take a while. And last but not least, there you have correspondence related to fee assessments. Depending on your jurisdiction in Canada, the filing fee for FOI requests differs. In BC, we've just come into having our own $10 filing fee, which is a step backwards as far as FIPA is concerned, and something we're hotly trying to contest. But it could be that that's the only fee you pay for a request. But sometimes there's actually fee assessments that go on top of that deal with the volume and complexity of research involved. And those are assessed. You don't have to pay those automatically, and there's something you can contest if you're given a fee assessment. You can challenge it on various grounds. Typically, if you want to proceed, you'll have to pay a deposit, which is about half of the fee request in most instances. And then you can, by doing that, you can still complain. So you could say, I'm paying this under duress, so the request keeps moving forward, and I'm now going to contest this. And you can contest this on a couple of different grounds. The records are of public interest, which is a case you can make. You don't have the resources to be able to pay that kind of fee, which is an argument you can make as well, with greater or lesser degrees of success. Sean, did you want to add in on?
Yeah, I mean, the only other thing that I would sort of add is, you know, a lot of journalists who sort of do this work as part of their major practice will usually have a spreadsheet that tracks all of this information. So that's a really important sort of thing to keep in mind. So don't just like track it like sort of informally, because there's going to be a lot of correspondence that's going to be generated by this. Track it really professionally, because you can then sort of see where some of your freedom of information requests are lagging. You can sort of follow up with government about it. You can bug whatever analyst, right, is handling the file, because what we know is, in a lot of circumstances, if you're not on top of your files, government is not going to be on top of them for you. And that's sort of the sad reality of the freedom of information system that we have today.
Yeah, absolutely. You can just fall off the side of the desk and someone will call you, 2 months, 3 months down the road, say, are you still interested in this?
Or 5 years later.
Yeah. I have here on the screen too just screenshots of the Office of the Information and Privacy Commissioner for British Columbia and the Information Commissioner of Canada websites, and these are actually really good resources for requesters for a couple of reasons. On the one hand, they're going to provide just the overview of the Act, the various sections that apply, often in plain language. FIPA's website does this too, by the way, for BC. But they also have, and I'll use the Office of the Information and Privacy Commissioner for BC here, they have something called a sectional index, which is all the different sections of the Act that pertain to your rights of access, but also reasons for withholding information. And then they have a searchable index of decisions they've made when people have complained. So if someone's challenged, for example, the withholding of information because it's policy advice, or they challenge the withholding of information because it's related to law enforcement activities. And the OIPC, which is empowered to make decisions about whether that's been applied properly, if they've done that, then the entire case file is there for you. And this is an incredibly useful resource when it comes to filing requests, but also when it comes to any kind of challenges that you wish to mount about your requests. And there's really, two different kinds of complaints or requests for review or intervention that you would make about an FOI request. One is a complaint about delay or simply non-response, right? If your access rights have been breached because it's taking too long, it's unreasonable delay, then you can request intervention at that point, and you have to, of course, provide that information for them to be able to make a decision, which is why, as Sean points out, having a good paper trail is very important. And the other, of course, is filing a complaint about what's actually been released. If information has been either not effectively searched for, right? So they didn't give you what you think is actually out there, or they did give you something, but it's then you think unduly redacted. Information's been unreasonably withheld. Well, using the sectional index and using previous decisions to say, actually, this has been interpreted as public interest in these cases here, and this should apply. Most of the time, and it does take time and effort, right? That's the challenge with this. There's a bit of a game of chicken that government organizations play with requesters when it comes to this. Do you really have the wherewithal to contest and follow up? But most of the time when I've done this in the past, I have had more information released. In part, that's just because you get greater scrutiny of a request when it's up for review, and they know there's someone else looking. So it can be successful. And
but
organizations like FIPA can help with this.
Yeah, totally. But also keep in mind that one of the reasons why we have to go through all of this process is because there are so many exemptions and exclusions in our freedom of information law. By exemptions and exclusions, I mean basically rules that the government has put in place that allow them to withhold information. If there weren't those rules in place, and if they weren't so extensive, a lot of the bureaucracy that's associated with this process and a lot of the time lag that's associated with this process would actually go away. So when we get to our sort of next slide, where we're sort of talking about, other considerations, right? One of the really big considerations to also keep in mind is this is a pretty crappy system. And so it's really important to advocate for a better system. One of the reasons why we have such a poor freedom of information law, both in British Columbia and in Canada as a whole, and why access to information is so much better in the United States than it is in Canada, is because civil society in the United States was far more engaged in advocating for freedom of information down there than they ever were engaged up here. And that includes the environmental movement, unfortunately. Environmentalists down in the United States took a leadership role in advocating for freedom of information. And in fact, one of the major reasons why the United States has the freedom of information law as it does is because there was a United States senator who actually pushed for better access to nuclear testing information and how it was going to impact Hawaii. So again, that's sort of an environmental issue that really resulted in a massive reform to the freedom of information law that was in existence down in the United States. In Canada, freedom of information advocacy has mostly been the purview of lawyers and sometimes some journalists. That's not really a great situation to be in. So I know sometimes that freedom of information seems to be an issue that isn't exactly related to the environmental movement, but it really is core to the environmental movement, because if we cannot get good access to information, we cannot participate in the kind of evidence-based decision-making that is assumed of us in a democracy, and that's falling away every single day.
Absolutely, and here, and we are very happy to support FIPA organizations that are looking to advocate for FOI reform that would be, important for issues that you're working on. You don't have to be an FOI specialist or a legal specialist or expert to be involved in advocacy in this. And actually, as Sean points out, it's kind of better if you're not, because those are the usual suspects, right? And I think that the people who are going to be pushing the dial when it comes to true transparency are people who are able to attach it to particular issues of public interest, and certainly environmental issues are by definition of public interest. So our last slide here in terms of some final tips, and then we have some time for some questions and discussion here. Just some takeaways, both related to requests for records about environmental issues, but also just in general. So one is to not rush modification decisions. If you get an FOI analyst who is contacting you saying, would you like to rescope your request? Would you like to change the date range? Do you want to exclude this? Which can happen, right, as part of correspondence. There's sometimes very helpful advice, sometimes incredibly unhelpful advice. Just to not rush that. I've seen so many situations where people have filed pretty strong FOI requests that may be contentious and have been met with a, would you like to just omit these things here because it'll be faster, we'll get you the information faster. And they realize too late that that was the information that was really useful to remove. So think on that before, and you can also consult colleagues and allies on that. This is my law of access, right? An FOI file will move through the system at the speed of its most complex component elements. So again, if you are looking for records and you know that there's some stuff that's fairly easily accessible, right? Q&A documents, maybe some briefing materials and some reports. And then there's some other stuff that might be quite contentious, right? These particular emails or these advice that was given to ministers. Consider bracketing those off. Or, and my last point on that, request an interim release of records. When a request is in progress and it's, there's been an extension taken and it's taking some time, you can contact the analyst and actually ask formally, could I please have an interim release of the records that have been already reviewed and processed? And there's some good jurisprudence on this in British Columbia that you can rely on if you're looking for that kind of stuff. That can mean that you get half of it now, half later, but that's better than none of it now. So often we file these requests when access delayed is access denied, when it's a timeliness that's important for us, and it may not be useful for us to get the information 6 months downstream. And then to collaborate and ask questions, and this has been my experience with the entire FOI community in Canada, is that the people who are doing this work and are passionate about transparency and have been kind of doing the filing for a long time are eager to share and collaborate. And pass on, release packages, but also some tips of the trade and some war stories that might be helpful for us. Certainly, how I learned my first requests were asking journalists for some assistance with this. So, if you see people who are doing work in the space, reach out to them, right? And that's a network that can really be successful for advocacy, but also for just obtaining records of interest. Some final tips from you, Sean?
Yeah, I think you actually covered it pretty well, and I'm excited to get into any questions that this group has, because really, I mean, this is also about filing freedom of information requests, is about participating in an evidence-based community. And those evidence-based communities around the world are really under threat right now. We need to form better communities than we have right now around the idea that evidence matters, around the idea that evidence should equal action. And filing freedom of information requests and connecting in with other members of evidence-based communities is really how we're not just going to be supporting better government decision-making, not just how we're going to be supporting better advocacy within that framework, but also how we're actually going to be supporting democracy.
Here. So I do want to thank my colleague Sean Holman for joining us and sharing his wisdom on this today, and thank all of you for participating here. Of course, we will still have some time for questions, but we're going to stop the recording of the event now, so everything that's come before will be accessible down the road for those who missed it, and the questions and answers are for our eyes only.
So there we go. Thanks very much for joining us for that. I really enjoyed the event. It's always great to hear some of the advice that's offered by Sean Holman, who's such an experienced requester of FOI records, but also an experienced advocate for transparency and a veteran journalist working on issues around climate change. If you're interested in events like this, I really encourage you to become involved with the BC Freedom of Information and Privacy Association, BC FIPA. You can find a lot of information on our website, just about FOI in general, some of the research that we engage in, our advocacy work, trying to push for better transparency laws in British Columbia and across Canada. You can also subscribe to our mailing list via our website. Chance for you to find out about any of these upcoming events that we have that deal with issues like this and other issues related to information and privacy rights. I also really want to encourage you to help us to do this work. And you can do this by becoming a donor, by donating to FIPA on a one-time basis, or even better, on an ongoing basis. Donations are incredibly important for us. They allow us to continue to do public education, advocacy work, and legal research, trying to really push at issues that are so important to the public interest, but often are considered to be a little bit too niche to really generate that groundswell of support. And we really want to try and push at these issues and improve access to information for everyone. So I do invite you to join me in donating to FIPA on an ongoing basis. And if you're really passionate about these issues, you could also, via our website, find out about how to become a member of FIPA. You can become a member as an individual. You can also become an organizational member, and organizations play an important role in helping to give us a sense of the issues that are important on the information and privacy horizon to help us to kind of focus our advocacy work. So thanks again very much, and we'll see you next time. The BC Freedom of Information and Privacy Association is an organization whose mission is to improve and defend privacy and transparency as vital components of a free and democratic society. We envision public agencies who are transparent in action and decision, people in control of their privacy and personal information, and privacy and transparency embedded in law and policy. We're one of Canada's few advocacy groups dedicated to access to information and transparency and privacy issues. We conduct research into the public opinion, policy, and law that intersect access to information and privacy frameworks in BC and across Canada. And this includes monitoring the performance of public bodies, governments, and regulators in the sector. FIPA commissions studies and provides material that empower lawyers, journalists, students, and the public. In turn, we are frequently consulted on policy issues by politicians and government officials. FIPA's work encompasses legal research, public legal education, public assistance and aid, and law reform that focuses on transparency and privacy issues. If you're interested in these issues and you'd like to learn more, or if you'd like to contribute to FIPA as a donor or become a member of the BC Freedom of Information and Privacy Association, I encourage you to visit our website at fipa.bc.ca. You'll also find us on Facebook, Twitter, LinkedIn, and YouTube. Thanks very much.